On 10th of September 2021, the Standing Committee on External Affairs presented its report on India and international law. In this report, the committee discussed several international legal issues and provided recommendations to resolve them. In this video, we will look upon those recommendations and issues relating to international law. But before moving further, do hit the like and subscribe button, because as I always say, the content which you will get from this channel, you won't find anywhere else on YouTube. So let's start. These are few areas where committee has provided its recommendations. So starting with how international law has been applied in India. Next, moving on to extradition treaties. Moving further to asylum. We will be also discussing international cyber security issues, and lastly, financial crimes. So let us start with application of international law in India. So you must be aware of two theories relating to the relationship between international law and municipal law. They are monistic theory and dualistic theory. Now, monistic theory says that both international law and municipal law forms a part of one universal legal system. So it means that they are not separated. On the other hand, dualistic theory says that international law and municipal law belongs to two different separate branch of law. So in other words, India is a country where we practice dualism. It means that international law is not directly applicable domestically, and this must be implemented through some legislation passed by Parliament. Now, over the year, it has been seen that Supreme Court has deviated from this principle. For example, in Vellore Citizen Welfare Forum case, the Supreme Court held that the rule of customary international law, which are not contrary to the municipal law, shall be considered to be the part of domestic law. Likewise, Supreme Court referred to certain provisions of CEDAW when it found that there exists no law on sexual harassment at workplace in India. I have made a separate detailed video on Vishakha case. I recommend you all to click the I button above and watch that video for more details on the case. So in the light of these differences between the executive and judicial practices relating to international law, certain recommendations have been made. So Ministry of External Affairs is required to coordinate with other ministries on matters where there exists vacuum in domestic law. So it happened in Vishakha case where no law existed on sexual harassment of women at workplace, and similarly ministries need to come together to find out more such areas where there exists vacuum. Also, there is another recommendation that a working group should be set up so that Indian capacity and expertise in international law can be improved. Next, extradition treaties. So what is extradition? You must be knowing that extradition is a process for surrender that is made upon request of a person who is alleged to have committed some crime in one territory and residing in another. But what we see is that there is some problems in executing these extradition treaties. These problems can be classified into two heads. First of all, that there exists a delay in extraditing offenders where India has already signed some extradition treaties. Second issue is that these offenders, they often reside in those countries with which India do not have extradition treaties, so making it more complicated to bring these offenders back to India. Therefore, the committee recommended that such countries should be found out and more extradition treaties should be signed with them so that offenders cannot take the advantages by residing in those countries. Also, it is important that the delay in extraditing offenders should be reduced so that these proceedings can happen more quickly and in speedily manner. Moreover, there exist certain mutual legal assistance treaties. Now, what are these MLATs? So this is a kind of arrangement where one country can ask another to assist them in matters relating to identifying and locating some persons, taking evidences, or obtaining statements. Presently, India is having 40 MLATs with other countries. Above that, within these 40 MLATs, 845 requests are pending with various countries regarding assistance. So the committee has recommended to establish a task force to identify what are the reasons for this much pendency. And also, there is a need that India should sign more MLATs with other countries. Another relevant area is asylum. So any person who is seeking international protection from persecution is called asylum seeker. So a person must be facing some threat in his previous country, and for that reason he has decided to migrate to another one. Now the host country may or may not grant refugee status to an asylum seeker. The committee has noted that in India, the existing domestic laws that regulate the entry, stay and exit of foreign nationals are inadequate to deal with refugees. We do not have any specific law relating to refugees or asylum seeker. Presently, we are dealing with them under Foreigners Act 1946, Passports Act 1967 and other executive rules. At this point, you should also know that globally, refugees are regulated under United Nations Convention on the Status of Refugees 1951 and its Protocol of 1967. India is not a party to this convention or its protocol. There is certain reasons that why India is not a party to this particular convention. India believes in a concept of shared responsibility of all countries in any refugee crisis. But the convention or its protocol does not deal with this concept of shared responsibility. That's why India is not willing to join this particular convention, and it rely on its domestic laws which deals with foreigners and ultimately refugees. Therefore, the committee has recommended that there should be some domestic protocol on the status of refugees and asylum seeker. Specific agencies should be given specific responsibilities to ensure more accountability. Also, MEA should make an attempt to introduce this Indian concept of shared responsibility of all countries within the international refugee instruments. Next in the line is a technology-oriented issue, international cyber security. Now, India has made significant diplomatic efforts to ensure global cyber security. However, in spite of India's huge expertise and resources in IT sector, India do not control any root servers. Now, what are root servers? So basically, they allow any country to regulate, modify or block internet traffics. So out of 13 root servers worldwide, none of them are located in India. Therefore, the committee has recommended that India's IT resources should be used in a manner to strengthen regional instruments on cyber security. Likewise, domestic laws on cyber security should be made in accordance with international law standards. Also, India should focus on preventing and preempting cyber attacks. Also, India should make an attempt to achieve data localization. Now, data localization is very important for national security because it restricts the free flow of data across the geographical boundaries. Data localization mandates any company collecting crucial data about its customers to store and process that data within the boundaries of the country. Presently, data is stored in a cloud which are not located within the boundaries of India. So that's why it is a major concern from data protection point of view. Lastly, we come to our final category, that is financial crimes. Now, financial crimes are important from international perspectives because they are transboundary in nature, and recently there has been increasing stances of transboundary financial crimes. So for this purpose, the committee has recommended that an international legal framework that should address transboundary financial crimes should be brought in picture. As of now, India has 42 MLATs with various countries in criminal matters. The committee is of the view that this number of MLATs should be increased to seek more assistance in financial crimes. Also, committee has suggested that the Fugitive Economic Offenders Act of 2018 should be reviewed. So you must be knowing that this act seeks to confiscate properties of economic offenders who have left the country to avoid facing criminal prosecution, or they have refused to return back in the fear that they will be prosecuted once they arrive within the territories of India. So there is a problem with this particular act, that the judicial procedure of declaring any person as a fugitive offender has been very slow, and also that these cases cannot take place against anyone unless the money involved in this whole matter is more than 100 crores. So the committee has recommended that the cap of 100 crores should be lowered down so that many more small offenders can also be brought within the ambit of this particular act, and also how these proceedings can be made in more speedy manner. I hope you have found this video informative and get to know many new and detailed issues relating to international law. If yes, then don't hesitate to hit the like and subscribe button. Your small gesture gives me a motivation to make more and more videos on these similar topics. So this is all for today. Thank you for watching.